This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 6th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi everyone, my name's Elaine Taylor-Shaw. I'm a patent scientist at Murgitroyd and I'm part of the electronics group working in our York office. And I'm delighted to say that I have one of our directors, Rosie Hardy, today, who works in the mechanical team, but also works in the York office.
Hello Elaine, it's good to talk with you. I know that you've got quite a few questions to ask me about this particular topic of ownership because it's quite interesting and it's sort of one of the key foundation stones of intellectual property, and it helps us understand why it's so important and gives us an overview in terms of the good, the bad and the ugly.
Yeah, that's right. Yeah, we've got quite a few questions to get through today and hopefully this will help others out there understand a bit more about ownership. So yeah, I'll just crack on. So the first question is, what are intellectual property rights? And what is it that you actually own?
That's a really good question because people don't actually genuinely understand what they have. And you can look at intellectual property in lots of different ways. So for a start, it's a legal right that you own, and that's regulated by governments and a legal system. And that's an international system too. And then you can look at it as a type of property in terms of the fact that it can be sold or licensed, you can inherit it, you can secure money against it, and so forth. And then it's an asset as well that can actually give you value. It can add value to your business, or it can be used to generate an income, or it's a type of monopoly in the sense that it gives you control over your innovation.
Sounds pretty good to me. So you've talked about, the importance of ownership. So what different types of intellectual property rights are there?
I'm a patent attorney, so my world centres around patents, and patents protect new inventions. So that means how a product works, what it can do, how you make it, what the product is made of. You could think, say, of getting a patent for a COVID vaccine and the component parts of that COVID vaccine, or the method of safely storing biomass, a pivoting hinge for an aeroplane wing, temperature sensor for a freezer. There's a whole range of different types of inventions that can be patented. Then there's trademarks, and trademarks protect brands, and they include names or logos. You can have trademark protection for a slogan, sounds, and even an action. Registered designs and unregistered design rights can protect the visual appearance of a product. Then you have copyright, which protects the content of a creative work, and they apply to works like literature, artistic works, photographs, music, dramatic works, films, radio and broadcasts, sound recordings, like this one, software programs and published editions. And then you've got database rights, which are often forgotten, and these protect the data content of a database too, which can be very valuable. And then you've got know-how, which protects the confidential information or trade secrets relating to a product. People may have heard about the recipe of Coca-Cola being a trade secret. And the story goes that no one employee of Coca-Cola knows the entire recipe. It's split between different people so that it remains confidential. And that is something which is an important intellectual property right that you can rely upon and sell or license or give access to in a controlled way.
So you said that you're a patent attorney. So I think today we're just going to focus on patents and, the approach in the UK. So what do we have to think about in relation to owning a patent?
Good question. So the first thing that we need to think about, obviously, is who owns the invention. that's been created. And then following that, we need to think about then who has the right to protect that invention and get a patent for it. So the patenting process means that, first of all, you have to apply for a patent application. And then once that's been approved, then you get a granted patent. It's a process, and there are various different steps that we have to consider. So the deviser of the inventive concept, the invention, is the primary owner of the invention, unless there are any agreements or rules of law in place that have transferred that ownership across to somebody else. And the inventor should be a person, and that can be a natural person or it can be a legal entity like a business or a corporation or an organisation. And the agreements that I mentioned earlier, they could be an assignment agreement where the inventor sells the invention to somebody else, or it could be where an invention has been gifted, inherited through the death of the inventor. Or it could be where you've got a contract between an R&D company and a customer, and there's been a relationship there where you are developing a new product for your customer, and there's an agreement in place that sets out specifically that that product that is developed, invented, belongs to the customer. And then the other thing to think about, particularly in recent times and the rise of AI inventions, is that is the AI machine the inventor? And can he be considered an inventor in relation to patent rules and so forth? And there's been a case in recent times, and there have been international decisions made about this. And the UK Patent Office and other patent offices around the world have decided that AI machines, artificial intelligence machines, cannot be considered to be inventors of an invention because they're not natural people, nor are they legal people. They're not legal entities. And as a result of that, they cannot be considered to own the invention either, and they don't have the rights either to transfer the invention to somebody else through an agreement or a rule of law. The idea being that the person, the legal entity, the people who were having an input into that AI machine, so who trained it, who's analysed the data and the results of the AI machine, who's joined the dots of what that AI machine has been working on, is considered to be the inventor. And so that's where AI technology is moving in terms of ownership of patent rights.
That's really interesting, Rosie, and good to know that machines won't take over anytime soon. You mentioned that the owner of an invention or a patent has to be a natural person, or it can be a legal entity such as a business. So what happens in the case of an invention made by an employee who is a natural person and belongs to a legal entity?
There are specific considerations for inventions created within the remit of being an employee and an employer. In the UK, there are specific rules that govern who own an invention made by an employee. And the invention shall belong to the employer if the employee was making the invention during the course of his normal duties and where an invention is expected to result. There's another situation where an invention will belong to an employer, and that's where, again, it's made during the course of the employee's duties or during his working time. And because of his duties and particular responsibilities, the employee has special obligations to further the interest of the employer. So those types of situations relate to directors, for example, where they have senior positions of responsibility and there is that special obligation and responsibility to further the interest of the employer. With these rules in place, you've then got a situation where there's an automatic transfer of ownership from the employee who's created that invention, and it's now considered under these rules to be owned by the employer.
Great, that sounds quite complicated, and I'm assuming there'll be loads of agreements and things in place or recommended in businesses in the situation where employees working under them are expected to develop products and such like and inventions.
So over and above these rules, it's always recommended that you make this relationship clear and the transfer of ownership of the invention clear. And so we always recommend that you set out in a contract of employment specific paragraphs highlighting what happens to inventions and how the ownership is transferred to the employer during the course of their employment and employment duties. And that contract very clearly sets out and everybody understands what then is going to happen with the ownership of that invention. So you still have, even though you might, as an inventor, have transferred your ownership to somebody else, you still retain the right to actually be listed or mentioned or designated as the inventor in relation to the invention that's described in the patent application and protected in the patent. And there are rules and regulations around that. And at a particular stage during the course of the prosecution of the patent application, you will be invited as the inventor to provide your details so that you can be named as the inventor of the invention. Another aspect of employee-employer inventions is to consider the benefit that the employer gets from owning your invention and having a patent to your invention. And that can be considered in some situations to have been an outstanding monetary benefit. And if your employer does make a lot of money from your invention, then you might be able to apply for compensation for a fair share of that benefit. And there's a process in place in the UK which will allow you to apply for that compensation. And it has to be made within 1 year of the patent actually ceasing to take effect. And there's been a recent case, actually. Mr. Shanks took on his previous employer, Unilever, and it went right up to the Supreme Court because there were some questions over how do you assess what the outstanding benefit is. It was interesting because this case clarified what you look at and which parts of the business that you look at to determine whether or not the profits made from the invention that Mr. Shanks invented genuinely was an outstanding benefit to Unilever. The courts also have rules on how to decide what a fair share of the benefit and the award can be. So it's regulated. And then employers can sometimes have what's called a collective agreement with their employees who are creating inventions, and there can be a financial reward for any of the patent applications that are filed for their inventions. Now, these collective agreements void the opportunity to go for a compensation award at a later stage. But it's a good incentive, and I've worked for many clients who have this financial award scheme in place, and it's always proved to be a good thing and worked well.
That's great, Rosie. It sounds quite complicated when it comes down to employer-employee relationships and ownerships in terms of what the employee has invented. So why is it important to work out who owns the invention?
Once you've worked out who owns the invention, the owner of the invention then has the right to apply for patent protection. And you have to demonstrate before a patent office when you apply how it is that you have the right to apply. That's part of the process. And there needs to be a clear understanding of that. So there are questions that are asked and maybe documents that you have to show. And one of the ways in which you can achieve that clear understanding is by having contracts in place. There can be sometimes disputes over the ownership of an invention and the ownership of the right to apply for a patent or a patent that's subsequently granted. And the courts and patent office can decide on those disputes. and decide what's going to happen to the ownership of that invention and any patents that are granted. I dealt with a case once where we used the rules governing the ownership of employee inventions and the ownership being transferred to owners, where a disgruntled ex-employee had taken an invention that belonged to his employer, and he took the invention that was very nicely set out on a memory stick to his new employer. And a couple of months later, we saw the patent application filed in the name of the new employer. And we were able to go to the UK Patent Office and argue that the patent application that had been filed did not belong to the new employer. So these rules in relation to who owns an invention are really important.
In terms of people out there, there's terminology that are used for ownership in terms of patents and patent application. What is the owner called in terms of terminology and legal terms?
When you apply for a patent application and you have the right to apply for a patent and you file that patent application, the owner of the patent application is called the applicant. And then once the patent is granted, you then become the patentee or the proprietor of that patent.
Oh, that's great. And the applicant and the proprietor can be different from the inventor, that's right?
That's right. If there's been a change of ownership of the invention, then that means there's a change of ownership of the right to apply. And then during the course of the patent application prosecution process, you could also have a change of ownership. So if an agreement is made between the applicant and somebody else, then you can record that change of ownership whilst the patent application is still being considered.
Thanks, Rosie. That's been absolutely smashing. You've answered a lot of questions and given people food for thought in terms of securing their ownership of patents. So that concludes our first part of this podcast, 2-part series. And we'll be looking forward to speaking to you again in the second part. So thanks very much for your time and I'll speak to you again soon.
Thanks, Elaine. Please feel free to contact us if you have any questions. Rosie Hardy or Elaine Taylor-Shaw, we're both based in the York office. We'd be more than happy to answer any question and we'd love to help. Thanks again.
Yeah, thanks.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.